Hey guys, Alex Rubian with the New Jersey Second Amendment Society. In December, we promised you that we're going to be supporting a lawsuit challenging and fighting against New Jersey's unconstitutional red flag laws. We vetted a lot of lawsuits out there. We worked with many different attorneys, and I'm happy and proud to announce we're going to be working with Albert Resciano, who currently has a class action lawsuit in federal court challenging New Jersey's unconstitutional red flag laws. Albert, we cannot thank you enough for the work you've done. Thank you so much.
Thank you.
You want to maybe just tell our members and our supporters a little bit about the case, why it's so important that they support it and help fight back, because what you've told me is just unbelievably egregious. You cannot. I just cannot believe this is America that these things are happening to. From the stories that Albert has told me. So, Albert.
Well, thank you very much, and I want to thank your Second Amendment Society for helping us support this litigation. It is extremely important. First, I guess we should start by understanding a couple things, and it'll put it into context why this is such a problem. We have a Fourth Amendment right against illegal searches and seizures. We have a Second Amendment right to bear arms. You have a First Amendment right of free speech, and you have Fifth and Sixth Amendment rights to be able to know the charges against you, confront witnesses, write for counsel. The new red flag law, which was passed in June of 2018, but went into effect in September of 2019, will violate all of those fundamental constitutional rights. It is literally nothing but a gun grab. Mm-hmm. And that has been basically stated by the AG's office in their, what I call the publicity tour, that they went around to the various counties with the county prosecutors. And, their position is to the police officers, issue this new law, even though you may have another law, such as the Prevention for Domestic Violence Act, where if you have a violation of that, they're going to take your firearm. Issue this law in addition to that anyway, because if the restraining order gets dismissed, which would then ostensibly mean that your firearm should be returned, you still have the Temporary Extreme Risk Protective Order, the TERPO, under the Extreme Risk Protective Order Act, to keep the firearms away from the person.
Yeah.
So that is clearly, when you say use it for this purpose, it clearly is a gun grab. There's no doubt about it. What makes the law so egregious was that when they were originally drafting this law, the original draft, and we've had a copy of it, we've had the opportunity to see it, talks about there being a requirement for probable cause. It mentions probable cause 6 or 7 times in the draft. And you have to have probable cause in order to issue a TERPO. You have to have probable cause in order to have a search warrant for the firearms. And ultimately, if you wanted to get a final extreme risk protective order, known as a FERPO, you had to have a standard of clear and convincing evidence. Mm-hmm. Now, clear and convincing evidence is a pretty high standard. It's not as high as a criminal standard of beyond a reasonable doubt, but it's certainly much higher than a preponderance of the evidence standard, which is your normal standard for civil lawsuits. As I try and explain it to people, because sometimes people say, oh, well, can you define it? A preponderance of the evidence is an ever so mere slightly tipping of the scales of the justice one way or the other, 51% to 49%.
And just for the viewers to realize, you have good cause and then you have probable cause. And what they did in the New Jersey red flag laws is they went and used the lowest standard possible.
Right. And I'm going to explain that to them in a second. But so I just want you to understand that this is what they did. They had this law, and the law said that we were going to use clear and convincing evidence for the final extreme risk protective order. And let's just say that's 75% proof. And then you have beyond a reasonable doubt, which is 95% proof. Well, the original law, which had probable cause, which is what constitutionally under the Fourth Amendment they have to have, and clear and convincing evidence for the final, when they come out with the final law, they have no mention of probable cause anywhere in the statute. The basis for the cause now is only good cause, and the final burden of proof for taking somebody's firearms under a FERPO is now only preponderance of the evidence. Somewhere along the line, they knew what they had to do. They knew what the proper language was. Then they went anyway and changed it and watered it down and made it facially unconstitutional. So clearly, whoever was handling this did it intentionally. This wasn't a mistake. They purposely violated and will violate probably anywhere from 3 to 5 of your fundamental constitutional rights. So what the law now says is to a judge, if you find good cause, you'll issue the turpo. And if you issue the turpo, you will issue the search warrant automatically. Well, what that means is that no longer are you meeting the Fourth Amendment of the federal Constitution, the Bill of Rights, or under New Jersey's Article 1, Paragraph 7, which also requires probable cause for the issuance of any warrant. So instead of having that, now you're issuing a search warrant on good cause, which is clearly, fundamentally in violation of everyone's civil rights. And they did it intentionally. Now,
well, it is New Jersey, so of course they would do that.
well, this is New Jersey, and New Jersey's big argument is to the court, to the federal district court where we sued, was that, well, you have all these other states, you have 15 or 18 other states that have these laws. But as I said to the judge, they're apples and oranges. It's not a question of quantity, it's a question of quality. Don't tell me there's 18 other states with these laws and they're being upheld. Tell me exactly what those laws are. When you look at those laws, they are fundamentally different. Many of them give notice requirements to people, even if it's just some. Rights for counsel. Some don't have any search warrants. Others have search warrants that are only based upon a separate analysis on probable cause. Very different from what we have. Because somebody else has a facially constitutional law and they've upheld their law, that doesn't mean that our facially unconstitutional law should also be upheld.
Yeah,
and that's the logic that they came to the court with. And that's a dangerous logic. And we know that the AG's office will refuse to enforce known unconstitutional laws because they've done it in the past.
Yeah.
And as I said in my brief, we found it to be a curious position that they're taking regarding this law. And look, the bottom line is the truth of the matter is it's political expediency. This is what the head guy in the executive branch wants.
Yep.
And he's their boss, and he's giving the marching orders. And despite the fact that everybody takes the same oath of office that George Washington drafted over 200 years ago that says that they will uphold the Constitution, they're not upholding their oath. They're violating their oath. They're not upholding the Constitution. Instead, they'd rather uphold the directives of an individual that wants to take your guns, wants to take all of our guns, and in doing so is willing to violate all these laws. The first time anybody is going to know that you are subject to a temporary extreme risk protective order is when they show up at your house with the order and say, "Hi, here's your order, here's your search warrant, give me your guns." Okay, so right there, they have now violated your Fifth and Sixth Amendment because you were not given any notice. You were not given any right to confront the witnesses. You were not given any right for representation. You were not given any right to present evidence.
Exactly.
And they've done all this. And their position is, yeah, but we're going to give you a hearing later on, so that ameliorates our violation of your constitutional rights. And meanwhile, common sense, but also case law says, no, when you violate a constitutional right, the damage is done the instant it's violated.
Yeah, I want everybody to understand for a second, because every week we're getting phone calls and emails from people that are literally having the police knock on their doors to confiscate their guns, take their guns away, search their homes, and they don't even know that they're being accused of a crime, many of which, in the cases that I've read about and the people that have contacted us, it's just purely based off of hearsay. Just based off of hearsay and just knock, knock. We're here to take your guns away, sir or ma'am, and give us everything. We're going to search your home. Oh, and by the way, you were being accused of this. I mean, it's so disgusting that the way people call us up that they don't even know that they're being accused of something. They have no opportunity to defend their name. and against these false accusations many times, which is happening. And the government of New Jersey's position is, we'll take your rights away first, and then we'll give it back to you when you prove your innocence. We know where that happens around the world, and it's sickening to say that this is America, and that this is even happening in New Jersey. Because if this was any other issue, there'd be riots happening in the streets. So let's just backtrack for a second, because this is why this case is so important. Why don't you tell everybody how the judge started the hearing when you guys went to federal court?
Oh, well, when we went to federal court, Judge Martinotti, who's
sorry, this all makes me laugh, but go on.
Who's the judge who's hearing the case? First off, understand that my client was charged in Camden County. My client was charged despite the fact that he had committed no crime. And actually, virtually every TURPO that's going to be issued, there's not going to be any crime. Because if there was a commission of a crime, they would move under the statute for that crime to arrest a person for a search warrant to take their weapons. The whole point of the TURPO is there's been no crime. These are thought crimes. So these are pre-crimes. They're pre-cogs. This is right out of Tom Cruise's Minority
Report. Yeah.
It's and that's the other scary thing about it. And yes, you're right, because most of these things are going to be, just like with my client, somebody is either going to say that they're afraid of somebody, or that they have a concern, or that somebody said something. In my client's case, they didn't like what he had to say. Clear First Amendment right. He wasn't espousing any violence. He wasn't threatening anybody. He never said he was going to harm anybody.
Is that your opinion, or was that the opinion of somebody else?
That was in the police report. The police reports flat out said he did not threaten anyone. Despite that fact, they went and got a TURPO anyway. And they did it by instead of showing the court a copy of the video that I've now had the opportunity to see of the interview with him, which was, and I'll tell you, it was August 5th of last year, and the TURPO was not issued till September 6th. So if he was such an imminent threat, and you're supposed to be in imminent danger to yourself and others, it's an exigent circumstance. Well, it couldn't have been that exigent if they were watching him for months and then they interviewed him, and then it was another 30 days before they went for the TURPO. But when Judge Martin, so when we got the case, I talked with my client. My client wanted to be the person to help everybody out there, to help all of your members. He was going to be the guy, if he needed to be the guy, to stand there and say, enough is enough. Synonymous with your client should recognize the names of Heller and Miranda. Well, maybe one day they're going to recognize the name of Greco in the same fashion. And so we came up with a plan, and we realized that we wanted to challenge the constitutionality of the statute. So we realized we didn't feel we were going to get a fair or proper venue in the Superior Court. Not that the Superior Courts are not fair and just, but it was a statewide issue, and we wanted a preliminary injunction to stop for the whole state, and we felt that the best place to argue these fundamental federal constitutional rights was federal court. So we filed the complaint in federal court. We filed for a preliminary injunction. And what you were asking was, when we went back for that preliminary injunction on November 20th, the judge walked out, said hi to everybody, and started the conversation by saying, can we all agree that this statute, as drafted, is facially unconstitutional? Well, that sounds like it's a pretty good start for us.
It sounds goosebumps down my spine just hearing that a federal judge would say that, because it literally makes your blood boil that these things are happening in New Jersey, and that people's rights are being trampled on. And that's like a breath of fresh air to hear a federal judge say that. Obviously, he hasn't put out his ruling yet. But,
no, we're still waiting for the preliminary injunction on the return date. To see if we're going to get another date to come back, or if he's just going to issue it. We don't know what he's going to do. While that's a good opening for us. Yeah. Both sides argued.
What did you say? What did the state say? I'm sure a lot of people
well, basically and we timed it. by the way. We timed it because the first 15 minutes was mostly the DAG talking and the judge questioning him and pushing him back and forth and trying to get him to say, yeah, okay, as drafted, it's facially unconstitutional. And he just wouldn't do it. Finally, the judge just sort of a little smile laugh said, you're not going to say it, are you? And he said, no, Judge, I'm not. He goes, nope, you're not going to give it to me. He goes, nope, I'm not. And he didn't. He wouldn't give it to him. And one way, from a legal standpoint, I can understand it. But from a tactical standpoint, I thought he made a mistake because I would have thought the better play would have been to say, you know what, Judge, we recognize the fact that as drafted, it was facially unconstitutional, but we took measures to cure that. And thus, that is not the issue. Mm-hmm. But that's not what he did. And so you understand, everybody out there, they knew it was facially unconstitutional. In August of 2019, both the Administrative Office of the Courts and the Attorney General's Office issued internal memos that said, this statute is unconstitutional as drafted. You cannot enforce it as it's drafted. Now, the proper procedure under what's called the Winbury Doctrine and under what you know about your federal and state constitutions with separation of power from your executive, your judicial, and your legislative branches and what they each do, what the proper thing to do was, in our opinion, was to turn around at that point and say to the legislature, look, statute as drafted is facially unconstitutional. We can't enforce it as it is. Here, take it back and redraft it. They even could have said, here, take it back and redraft it, and we recommend these changes to make it facially constitutional. That's not what they did. By an internal memo, they said, all right, ignore the law as drafted and do this instead, which you can't do.
Yeah.
You don't have the authority to do that. The courts don't have the authority to do it through their administrative powers because that is supposed to be for not the adjudication, but the administration of their internal workings. And the AG's office doesn't have the power to do it because they're the executive branch. And as Judge Martinotti pointed out, and we've cited case law to the New Jersey Federal District Court, Judge Martinotti, that said that you don't rely on the government and their largesse to not improperly use a law. That's not the point. And the judge even said to the AG, he said, well, couldn't a new attorney general come in and change the directive, issue a new memo? And he had to say, eventually he had to say yes. And then the judge pointed out, in fact, nothing even prevents this AG from changing his position tomorrow.
Exactly. And just for everybody to understand, this isn't just the politicians, the people you might be contacting at your offices when you support or don't support a law, just sat around in a room all day and just wrote. In New Jersey, you have what's called the OLS, the Office of Legislative Services. And those are the lawyers that they speak with the legislators and they say, oh, here's what we want to do. And then the lawyers, this team of lawyers in OLS, come together and they craft these laws. And then that's how they come up with the language on the bill and what becomes law. So this is like a perfect example of how many unconstitutional laws that they pass every single month, day, and year that are infringing on our rights that we want to start challenging. Because this is a perfect reflection of that we don't care. We just want to pass this. Let's see how much we can get away with.
Right.
Let's see what we can do. And the people, even more egregious on this issue is the fact that they didn't make this criminal because in criminal proceedings, this is a big problem that we've been having with people that have been served with TURPOs, is you would be issued an attorney if you could not afford one. But they made
technically it's not criminal, although it's in the criminal statute.
Exactly. Yeah.
Anything that begins 2C: in New Jersey designates it as the criminal statute. Yes. And this is in the 2C statute, but it's specifically not criminal. And the prosecutors and the judges are being very careful to correct themselves and say, the respondent, Your Honor, not the defendant, the respondent.
Exactly, yeah. So you do, if you cannot afford an attorney, which this will does primarily affect low income and poor minorities, you cannot afford an attorney, you will not be issued one, which is a constitutional right, which is is like the fundamental aspect of being an American. and they abuse that. They know that. So imagine you don't have $5,000 or $10,000 for a retainer to go hire an attorney to defend your name and make sure your firearms aren't taken away. Now you have to go to court by yourself and to go fight yourself against the state. I think that's another massive violation.
Well, that may go toward the equal protection clause and the equal protection argument, which we haven't even gotten to yet.
Yeah.
There's so much out there. I had to file a motion in the state case, and as the judge indicated, he said, there's a lot of really, novel, unique issues of first impression that I raised in that motion. And rightfully so, that motion shouldn't be decided until such time as the federal case is decided.
And just to clarify, you have a state case where you're with Mr. Greco,
yes,
where the state is trying to take his firearms and his Second Amendment rights away.
Yes,
and then you have you have a federal case going on where you're suing in federal court, challenging the validity of the law. And how is that opened up to you mentioned you opening this up to a class action?
Yes, we just recently filed a notice of motion for class action certification, which is a motion where we're asking the court to give us class certification for everybody that's been issued a TERPO, a temporary extreme risk protective order, in the state of New Jersey. So if you've been issued a TERPO, you would be included in this class if the court agrees with us, and you would have the right to opt out. So all of your members and any gun owner, or really anybody, period, that was subject to a TERPO would be part of the class. They could opt out. And then there's notice requirements that we've asked the court to approve that would require the state to quite literally give people notices of the class action suit while they're handing them the TERPO.
I love it. I love it. So just to clarify, you're getting issued a TERPO against you. The cops, they come to take your guns away. They issue the TERPO paperwork, and then they're all simultaneously going to be issuing the class action lawsuit paperwork. That's basically going to state that, hey, we believe this law is unconstitutional. You're part of now a class action lawsuit.
Well, it's not that the police believe, but they're issuing you a paper that says we, the people who filed the complaint, believe that the law is unconstitutional and we've sued, and that they have the right to be part of the lawsuit as part of the class action, or that they can opt out, and that the whole part of the whole allegation of the case is that our position is that that while they're serving you the TERPO, they're committing an unconstitutional act.
All right.
So it's a case that it really is a case that affects all of our citizens on multiple levels, and people don't get it oftentimes. They don't really see the impact, but they are violating so many of your fundamental constitutional rights. It's scary because if they do this, you say something that they don't like, now they come and they take your guns, and then in doing it, they violate your Second Amendment, they violate your Fourth Amendment, your Fifth Amendment, and your Sixth Amendment rights. Where does it end?
Yeah, where does it end?
If people don't stand up and be heard and push back, then they'll continue to do it in this area and in other areas until somebody finally does. And if nobody finally does, eventually you won't have any constitutional rights.
Let's wrap up there. Albert, I'm really happy you reached out to us asking for support. We're backing this, giving you a check for right now $2,000.
Well, thank you very much.
To help support the case. And that's all thanks to our members and their contributions and their donations. Becoming members, there's general, premium, and life memberships available. We take donations. nj2as.org. I like your style. I like your aggressive tactics and your charisma on this. This is really the kind of energy that we need in New Jersey. I think we've discussed 4 or 5 other lawsuits that I think Albert would be the perfect and fantastic attorney to join with our federal guys to start, fighting back against New Jersey. I'm in it to win it. I hope you join us. nj2as.org. I'm Alex Rubian.
Albert Rocinio.
And how can they find out more about you?
My offices are at 1500 Allaire Avenue, Ocean Township, New Jersey, 07712. My phone number, 732-531-2005. You can look me up on the web. I have a website, Resinio.com, and my email is aresinio, A-R-E-S-C-I-N-I-O, @Resinio, RESCINIO.com.
If you've been affected by these unconstitutional laws, you were asking us if we have any other members. We sent you their information. Please reach out to us, NJ2AS, and reach out to Albert so we can help you guys out. Signing off. Thank you again.
Thank you, sir.
All right. Have a great day.
You too.